Good evening. Happy Tuesday. So, Earl's criminal trial has gone on at a lightning pace. We've had 2 days of voir dire. That's questioning the jury to impanel the jury. We have had 2 days of trial. Both of the parties have rested as of 3:23 this afternoon. So all that's left is closing arguments and jury deliberations. We could have a verdict tomorrow morning, or depending on when you watch this, we could have this on the morning of the 14th. So that's amazingly fast. I was off. I had expected it to take twice to 3 times this long, and so I'm just plain dumb and wrong. But my excuse is I am a first-year family law attorney out of California who's never done a felony. So, you get what you pay for. If Earl is found not guilty, then when the jury comes back with the not guilty verdict, it's done. If the jury comes back with a guilty verdict, then the next step is going to be the state and the defense get to put on their evidence for the guilt phase, the sentencing phase of the trial. And the rules of evidence are somewhat more relaxed. Character evidence can come in a lot more easily. And then the jury is going to get to decide what sentence to impose, because Earl requested a jury verdict, and I'm not entirely sure with all these salacious details and if he's found guilty, the testimony of 3 daughters, all of whom believe that Earl molested them, or at least they allege that Earl molested them. I don't think that's going to be too awesome for a jury verdict. In my estimation, again, taking into account I'm a first-year family law attorney who's never done a felony, judges tend to be a lot more jaded. They tend to be less reactive emotionally, tend to. There will probably be exceptions out there, but they've seen this all before. They've dealt with pedophiles and child molesters and rapists before. They're not going to be as reactive to it because it's not new and exciting for them. So that's Earl's trial. We're going to cover the Decastro versus Ironton case, Pam Wagner et al. This is docket 31. Before we get there, when I first did a video on Chili's time is about to run out, he had 2 hours in my estimation to respond to the order to show cause, I got a lot of pushback about people saying that that Rule 6D extends Chili's time to act, because Chili receives all notices. He's served by mail. Because he's served by mail, any time period that he gets, like if you get 21 days after being served a document to react, like 21 days after service of a responsive pleading to file a amended complaint by right, something like that, this Rule 6D would kick in and say, well, because you get served by mail, you actually have 24 days to respond instead of the 21. You get 3 additional days. Now, the difference between what was happening with something like that and what happened with the court saying you have this specific deadline. So let me try to put this in a little bit better perspective. So there's a local rule that says you have 21. Here we go. So Southern District of Ohio, Local Rule 7.2 A2 provides that a memorandum in opposition shall be filed within 21 days after the date of the service of the motion. So because that time period kicks off with service, Chili would get an additional 3 days. So he'd have 24 days after the date of the service of the motion, because he gets served by mail. And everybody pushed back on me on that, but I'm going to stick to my guns. Now, it's not clear that the Sixth Circuit has ruled on it, but the 10th Circuit, there's a couple of cases out of the 10th Circuit, and there is an Eastern District of Michigan case that talk about it, but it's not clear. So United States versus Zook is the most current one, and it lays out that you have the date runs from the date of service. It's only triggered when you're after service, so it's not triggered. You don't get the 3 days if it is an order to show cause. Securities Exchange versus Harmon, I think, is the one that was better. Here we go. Appellants were mistaken. When the district court granted their motion for an extension, it did not direct them to act within a specified time after being served. Rather, it ordered a set date. November 13th is the deadline. In those circumstances, Rule 60 did not apply. So, this is 10th Circuit. So, for those of you who, you're still welcome to believe that Chile had 3 extra days, and that's fine. I don't believe he did. Because Rule 60 would not kick in because there was an order to show cause by, I think the last one that he blew for Lawrence County was November 17th. So he had until November 17th, not November 17th plus 3 days. So I'm going to stick to that. Anyway, that was my research for the night, so you're welcome. So this is the Lawrence County defendant's response in opposition to plaintiff's motion for leave to file a response. This pro se action was filed on April 22, 2022. On May 11, 2022, defendants Lawrence County, Major Chapman, and Jane Doe, hereinafter the Lawrence County defendants, filed a motion to dismiss for failure to state a claim pursuant to FRCP 12b-6. So I want you to listen to how this writer, this attorney, lays out her facts. She's going to make very specific allegations of fact. On this date, this happened. On this date, this happened. On this date, this happened. It's not going to be like, I feel attacked. It's on this date, this happened. This is what you're looking for. This gives the court what the court needs to make an informed decision. So, Southern District of Ohio Civil Rule of Procedure 7.2a2 provides that a memorandum in opposition shall be filed within 21 days after the service or after the date of service of the motion. However, more than 21 days elapsed from the date of service of the Lawrence County defendant's motion, and plaintiff failed to file a response. Thereafter, on June 29, 2022, this court's order to show cause provided the following in pertinent part. Plaintiff is hereby ordered to show cause in writing on or before July 22, 2022, why defendants Lawrence County, Major Chapman, and Jane Doe's motion to dismiss should not be construed as unopposed and granted for the reasons stated. Plaintiff may also satisfy the requirements of this order by filing a responsive memorandum to defendant's motion of the July 22, 2022 deadline. Failure to timely comply with this order will result in the pending motion being granted as unopposed for the reasons stated therein. Plaintiff failed to file a response to this court's order to show cause or file a responsive memorandum to the Lawrence County defendant's motion to dismiss by July 22, 2022. On August 11, 2022, plaintiff filed a response to this court's order to show cause. The aforesaid response provided the plaintiff until July 27, 2022, did not receive any filings in this matter. Plaintiff claims that on July 28, 2022, plaintiff received this court's order to show cause as the first item he received from anyone relating to this action. As a result, plaintiff requested that the case not be dismissed and to be granted the opportunity to pursue his case on the merits. On August 15, 2022, this court's order granted plaintiff a 30-day extension from the date of the order to respond to the Lawrence County defendant's motion to dismiss and the City of Ironton defendant's motion for judgment on the pleadings. The aforesaid order also rescinded the June 29 and July 21, 2022 orders to show cause. Plaintiff was required, per the order dated August 15th, 2022, to file his responses to defendants' pending dispositive motions or file an amended complaint by September 14, 2022. 1 day after this deadline, plaintiff filed an amended complaint. 5 days later, on September 20, 2022, a motion to dismiss was filed by Lawrence County defendants. Plaintiff once again failed to timely respond, and on October 24, this court entered an order to show cause, ordering plaintiff to show cause in writing on or before November 17, 2022, as to why the Lawrence County defendant's motion to dismiss should not be construed as unopposed and granted for the reasons stated. The order further provided that plaintiff may also satisfy the requirements of this order by filing a responsive memorandum to defendant's motion by the November 17, 2022 deadline. Failure to timely comply with this order will result in the pending motion being granted as unopposed for the reasons stated therein. On December 6, 2022, this court's order granted defendant's motion to dismiss and closed and terminated this case from the court's active docket. On December 7th, plaintiff filed a motion for leave to file response 2 days late. Attached to the motion for leave is plaintiff's response in opposition to defendant's motion for judgment on the pleadings. For the reasons set forth below, defendants respectfully request this court deny plaintiff's motion for leave to file a response in opposition. Number 1, argument Roman numeral 1. But before we go there, just did you see it was on this date, these facts happen. On this date, these facts happen. There's no ambiguity as to what the facts are. You're not asking the court to imagine or fill in the blanks. It's just cut and dry. On this date, this happened. On this date, this happened. And that's what Chile can't seem to grasp. And that's why that's one of the many reasons why Chile's not going to do well filing lawsuits. So Roman numeral 1. Plaintiff's motion for leave should be denied because a 2-day extension fails to meet the deadlines set forth in the orders to show cause. Because remember, it was November 17th. 2 days would be November 19th. He's still like half a month late. Plaintiff's motion for leave claims he is making a request for a 2-day enlargement of time to file his response to defendant's motion for judgment on the pleadings, and which also answers the order to show cause. Plaintiff further avers that he sent his response to defendant's motion for judgment on the pleadings to his process server for filing, and they arrived at the court late for filing in person on Monday, December 5th, which is within the deadline for responding. However, the orders to show cause required plaintiff to respond to the Lawrence County motion, or the Lawrence County defendant's motion to dismiss, by November 17, 2022, and respond to the City of Ironton's motion for judgment on the pleadings by November 30, 2022. Therefore, plaintiff's request for a 2-day enlargement fails to meet the deadline set forth in the orders to show cause. And then this is just saying that Chile failed to serve the Lawrence County defendants, but they're responding anyway because they think they should. And they should, because he was opposing their motion in his response. So with the understanding that, at least my current understanding, that 6D does not apply if there is a set deadline that is not triggered by service, the November 30 deadline he blew by 6 days, 7 days, or something like that. 6 days or 7 days, because he filed on December 7th, so he blew it by 7 days. That's a big one. I mean, if he'd missed it by a day or two, the court might be a little more lenient. If he hadn't established a pattern of blowing deadlines by long stretches, especially like this one right here. I mean, he blew this one by 20 days. So if he hadn't established that record, he might be more successful. But I think the odds are stacked against him on this one so far. So he 2 days isn't going to cut it because he missed it by a week to 20 days. And now Roman numeral 2. Plaintiff's motion for leave should be denied because he failed to establish excusable neglect. And that's the important word. It's not just neglect, it's excusable neglect. So plaintiff's motion for leave claims that his delay in filing plaintiff's response in opposition to the motion to dismiss is due to excusable neglect and was not intentional. Plaintiff further claims that he has acted in good faith but has been hindered in that he has not received 2 of the 3 orders to show cause, which resulted in delayed responses from plaintiff to this court. In this case, all documents filed by the Lawrence County defendants have been mailed to plaintiff at 1258 Franklin Street, Santa Monica, California, 90404. The aforesaid address is what was provided by plaintiff for service in this case, and in his response to this court's order to show cause. See Robb v. Smallwood. This is an Ohio case. I don't know exactly why they're citing an Ohio case, but that's fine. Appellant received proper service because the clerk sent the hearing notice to his address of record in Athens, Ohio. Although pro se litigants are held to less stringent standards, citing Jordan v. Jabe, they are not exempt from the requirements of the Federal Rules of Civil Procedure. That's Pleasant Bay v. Shelby County, and this is a West Virginia or Western District of Tennessee. It looks like it's an unpublished decision. That's a fairly weak citation. So that is, that's pretty weak. If plaintiff was aware that he was not receiving all filings in this case, he could have easily contacted the clerk of courts to inquire about filings in this matter. See Fox v. Wooford, which is another district court case, citing a Seventh Circuit case, which is outside of the Sixth Circuit where they're at, which stated all litigants, including pro se litigants, are responsible for maintaining communication with the court and monitoring the status of their lawsuit. See also an Eighth Circuit Court of Appeals decision. A litigant who invokes the processes of the federal courts is responsible for maintaining communication with the court during the pendency of his lawsuit. However, plaintiff has continually shown that he will not abide by the deadlines imposed by this court. In Jordan v. Jabe, this is a Sixth Circuit decision, which is good. The Sixth Circuit Court of Appeals held the following. The case is not being dismissed as a result of inartful pleading or any lack of legal training, but rather because he failed to adhere to readily comprehended court deadlines of which he was well aware. That he comprehended their significance is evidenced by his having sought their extension. The district court was generous in granting extensions which Jordan failed to utilize. The court went on to hold that, although this court prefers that claims be adjudicated on their merits, dismissal is appropriate when a pro se litigant has engaged in a clear pattern of delay. Again, citing a Sixth Circuit case. Thus, the case merited dismissal because Jordan failed to pursue his case despite 2 extensions of time. Likewise, in the case before this court, plaintiff has been given multiple extensions beyond the 21 days permitted in Southern District of Ohio Civil Rule 7.2a2 to file a memorandum in opposition to the Lawrence County defendant's motion to dismiss. Plaintiff has engaged in a clear pattern of delay by failing to comply with multiple orders of the court. Thus, dismissal was appropriate, citing an Eastern District of Michigan case. Accordingly, for the reasons set forth above, defendants respectfully request this court deny plaintiff's motion for leave. So, I'm gonna say that I think that the defendants have a very good shot of having the court deny the motion for leave. Now, the court may grant the motion for leave and then grant the defendant's motions for summary judgment and 12b6. But there's a good shot. I mean, there's a really good shot. And there is a chance that the court will, allow the stupid lawsuit to proceed. But again, younger abstention applies, so I don't know how far that's going to get. So anyway, thanks for watching. Have a great day.